वो वाले जो लोग जीते थे कौन से इलेक्शन में 8 जून या 10 जून के
जीते जी
तो फिर वो बन जाएंगे
जी सर 10 जून के there is a confusion about dates but 8 to 10 June that's absolutely correct because then the second order
8 जून है या 10 जून है
10 जून
कभी 10 जून का है कभी 8 जून
का है ये that's one of the discrepancies which the election commission also points out
नहीं इनका आपका क्या है 10 जून है 8 जून क्या मौकिफ है अली जफर साहब वो वाला इलेक्शन 8 जून का है 10 जून का है 8 जून मान लेते हैं 8 जून या नहीं
sir let's accept 8 June is correct but if that election is held to be valid, then the second order of the election commission, which is now impugned before the which was impugned before the Peshawar High Court, cannot stand. If the Lahore High Court accepts that rate, this second order will fall.
Either you take away the possibility, that possibility is a possibility.
Yes, it is.
Maybe not a probability, but it's a possibility.
Yes, my lord. Yes, it is.
So it is amounts to the same. Whether that's the test, I would imagine. I don't know.
My lord, that's exactly the test, and that's the test as laid down in Tirmizi and as
then the court said कि भाई अब तो ये infractions हो गया, अब इसको withdraw कर लो, तो उन्होंने कहा नहीं. आप इसको हम सुनेंगे 5 मेंबर बेंच प्लीज लगा दें
जी
क्योंकि वो लर्नर सिंगल जज सेड कि भाई इलेक्शन हो गए भाई खत्म हो गया अब ये या कर रहे हैं आप इलेक्शन जो भी आई डोंट नो व्हाटएवर दिस थिंग इज सो दे kept it pending and they said no please send it to a bench of 5 judges. The other way around suppose Peshawar dismissed it so Lahore allowed it ये भी हो सकता है
yes my lord
अच्छा
in either event the submission is that on the basis of Tirmizi the Peshawar High Court with great respect had no jurisdiction. If your lordship may see page
अगर हम समझे कुछ आप हमें ज्यादा बातें बताएंगे जमहूरियत के मुतालिक
My lord, may I just finish my engagement with this particular judgment? The combined read, page 20, the combined reading of section 208, 209 and 215 does not give any impression that the ECP has any jurisdiction to question or adjudicate the intra-party election of a political party.
My lord had observed that this is a judgment in rem.
Yes.
Or is it not?
It is, my lord, because it is under Article 201 of the Constitution, it will bind the Election Commission because it is now declaring a finding of the High Court on a question of law. So it will act as a precedent. In view of this, the Election Commission now cannot go against this finding in any case at all. It will apply in every case. This
effectively, elections are over. If we uphold the judgment,
yes, my lord.
So they don't need to hold
then
election.
215 is redundant because my lord, if the power under paragraph subsection 5 of 215 is taken away, then the Election Commission's authority to insist that intra-party elections be held and be held in accordance with the Constitution. That's the statutory language. In accordance with the Constitution of the political party. That is the language which is repeatedly used in 209, 208, 215.
Got it. Next point.
My lord, if your lordship may then please graciously look at page 25, and that's the last portion I am identifying. It has the right to contest election under a common symbol. This constitutional right cannot be denied to it on the basis of absurd provision of law. My lord, if
find that word very offensive.
My lord, this honorable court and the High Courts can either hold a law to be valid or a law to be invalid, being in violation of the Constitution. It cannot, without holding a law to be invalid, hold that the law is absurd. That means
if it was striking it down, it could be held.
Yes,
maybe.
Yes, my lord. Yes.
Not very legal language, but okay, acceptable.
So when they are not striking it down, not to follow it on the basis that it is absurd, means that they have not found it in violation of the Constitution, because if they did, then they should have struck it down.
Yes.
But if they did not, then they have to follow it. The High Court has to apply the law then. it can't simply walk away from the law saying it's absurd.
ठीक है, ये आप वो कह रहे हैं कि जो डिक्लेरेशन हमने नहीं मांगा तो कोई फर्क नहीं पड़ता है कि वो तो एक इनबिल्ट implied term है, उसका क्या कहेंगे आप?
My lord, the submission is that even if they have not sought a declaration, in view of this reasoning of the Peshawar High Court now, what is left in subsection 5 of section 215? Can subsection 5 of 215 be applied in any case from now on till any time in the future?
What's the answer?
The answer is no. If the party has given a certificate that elections have been held, the Election Commission has no authority to examine whether the elections were in accordance with the constitution of the party or the law. The certificate of the chairman of the party or secretary general of party, whoever is the competent authority, will suffice. That will be the end. That would be the end of the authority of the Election Commission. The only way in which the Election Commission will be able to invalidate an election is if such a certificate is not given.
एक चीज मुझे समझ नहीं आ रही है, एक तो होता बाद में इलेक्शन शेड्यूल के बाद आप जल्दी जल्दी चीजें कर रहे थे, ये वो आपको ऑर्डर मिला, वो इंटरिम इंजंक्शन का उन्होंने ऑर्डर लिया या नहीं मिला? वो जो पेशावर वाली हाई कोर्ट का एक वो बता दें। और दूसरी बात ये है कि ये इतने अरसे से आप इनसे कह रहे हैं कि इलेक्शन करवा लें, तो क्या वजूहात हो सकती हैं कि इलेक्शन नहीं हो रहे थे?
My lord,
I mean, I know it's a realm of speculation. If you don't want to speculate, fine.
My lord, I would hesitate from speculating. I would move away.
Fine.
My lord, our respectful submission in respect of these.
ये रघु साहब ये रोमन 3 में इन्होंने जाके फिर उसका इफेक्ट दे दिया खुद ही 215 का, ये क्या है फिर?
Sir, our submission with respect is that is the inherent contradiction which my lord the Chief Justice was pointing out as well on page 26. If 215(5) is an absurd law, then how can a writ be issued strictly and is entitled to the election symbol strictly in terms of sections 215 and 217 read with any other enabling provision of the Election Act? So if this is an absurd piece of legislation, if no action can be taken on the basis of this legislation by the ECP, what is the basis of the honorable judges of the High Court to issue a writ on the basis of that same absurd provision of law?
Unless subsection 5 is struck down.
Unless
the provision has been.
My lord, if subsection 5 had been struck down, then the scope of controversy before this honorable court and submissions would have been entirely different. But over here the situation.
खबर शामिल करते हैं। आपको बताएं कि मुस्लिम लीग नून के सदर साबिक वजीर आजम शहबाज शरीफ की असासों में 5 साल के दौरान वाज़ेह कमी आ गई है। इलेक्शन कमीशन में जाहिर करदा असासा जात की तफसीलात सुनो न्यूज़ ने हासिल कर ली हैं। मजीद जानते हैं वकील रहमान से। वकील रहमान, बताइएगा कि शहबाज शरीफ के कितने असासे हैं और इलेक्शन कमीशन में जाहिर करदा असासों में कितनी कमी आई है?
जी बिल्कुल, साबिक वजीर आजम